Welcome. Today is a really fun event that's been planned with the help of Anna Walker and the American Constitution Society. We are really excited today to host Civil Rights Duke in Durham in the 1960s with our special guest, Mr. Wade Penny. So Mr. Penny is a lifetime resident of Durham. He graduated from Durham High School in 1953. He's an alum of Duke. He got his bachelor's in 1957 and graduated from Duke Law School in 1960. He held the Richardson Foundation Fellowship for a year in 1960, where he lived in D.C. and worked on Capitol Hill in the office of Representative L.H. Fountain for the 2nd District of North Carolina. He was a public practice of law in Durham as a solo practitioner from 1961 to 1970, and later he represented Durham County in the General Assembly of North Carolina for 2 terms in 1967 and 1969 sessions. He also served a term on Durham City Council from 1975 to 1979 as the chairman of the Finance Committee. He engaged in a private family business since 1970 in executive positions. And 6 years, and today our event specifically focuses on 6 years after graduating from Duke Law. He, as a young attorney, argued Klopfer versus North Carolina before the United States Supreme Court in 1966.
And also leading today's discussion is Professor Joe Blocher. He's a professor here, and his principal academic interests include federal and state constitutional law and the First and Second Amendment. He's also a Durham native, and he returned to Durham in 2009 to join the Duke faculty and received the law school's Distinguished Teaching Award in 2012. He currently is teaching a seminar on the urban legal history of Durham. I'm in that class. It's a fantastic class and really interesting, and he's clearly very passionate about that subject. From what I've heard, he's hoping to teach it in future semesters, so all of you who go here should try to take it.
And even if you don't, just come.
Just come. So yeah, thank you to Professor Blocher and Mr. Penny and Anna Walker, and I hope you enjoy the event.
Thank you both for that really generous introduction and for the plug for the class, Anna. I see a lot of my current students here. Thank you to American Constitution Society as well for sponsoring this event. It's really fantastic to be here with one of our distinguished graduates whose incredibly rich professional life I won't retell because Anna and Christine has given us a little bit of an overview, and of course we're going to get to talk through some of the details here. I'll just say that it is a real honor to be here with Wade Penny to talk about really kind of what the possibilities are for a young lawyer and what they were then. In the interest of kind of contextualizing what happened and making it clear what the stakes were at the time, I wonder if you could just start us off, Wade, by talking a little bit about what Durham was like in the 1950s. You would have been in high school here, and then college, and then law school. This is the years after Brown and the early years of the Warren Court, and I just wonder if you could give us a sense of what life was like here.
Thank you, Joe. Number one, let me just say what a pleasure it is to be back at a very different Duke Law School from the one that I knew. You wouldn't believe it if I started telling you how small and quaint that building was compared to what we're in here today. But nonetheless, I don't think anyone who's attended Duke Law School, be it the old building or the new one, has ever had any regrets about the privilege it is to have a Duke legal education. And one of the secrets of it has always been the great faculty that we have been able to attract to Duke Law School. As Joe said, I finished Durham High in 1953, the year before Brown versus Board of Education. That decision really didn't make any impact here for 4 or 5 years. I believe Chapel Hill did not desegregate, which was the most liberal progressive community in North Carolina until 1960. The subject of civil rights almost never came up during my undergraduate days at Duke. Duke was very much a Southern university. I'd say 2/3 of my undergraduate class were Southerners. It was just a subject that wasn't mentioned. The only time I ever had it raised in a classroom was in the introductory course to American history. And our history professor, and I'm not going to name him because otherwise, he was held in high esteem as an excellent professor. And he asked our class early in the fall semester whether any of us saw an inconsistency between the fact that the people who prepared our food in the dining halls were not permitted to come out and share that meal at a table in the dining hall. And the classroom just, it rolled right off our shoulders, so to speak. There was just no response, and I've always thought he let us off far too lightly. Law school made a big difference, and I'm speaking now personally, that the thought process, the analytical process that you learn in law school, just all of a sudden at least I wasn't really conscious that I began to reassess all my outlook, but as that process took hold in one's medium of thinking, and then you were exposed to constitutional law cases, all of a sudden your understanding of the American principles of fairness, equality, and justice became a lot more forceful in your mind, a lot more relevant. Law practice in Durham, well, I was in Washington, it was a one-year fellowship sponsored by the family that owned Vic's Cough Drop Company. They offered a fellowship to a graduate of Duke, Wake Forest, and Carolina law schools to go spend 1 year in Washington with either a North Carolina senator or a representative. I was there 1960 to 61, the year that John Kennedy got elected president. And I mention that because I think for young lawyers that John Kennedy made a big impression on our assessment of what we wanted to try to do to further the progress of American society. And of course, that 1960 was really when the civil rights movement really began to get rolling with national publicity. At any rate, I came back to Durham because Washington, D.C. is a fascinating place, but I decided if I ever went back to Washington, I wanted to be sent by popular election. I didn't want to become a bureaucrat. So I came back and let me say this. At that time in Durham, there were probably not more than 4 law firms that had at least 4 lawyers. It was very much a city, and this was typical not just of Durham, but of any urban city or smaller town in North Carolina, that it was overwhelmingly either sole practitioners or 2 lawyers practicing together. And as I say, there weren't more than 4 firms here that had 4 lawyers. So it wasn't anything unusual to go and open your own office. I started out sharing offices with Dan Edwards, a former mayor of Durham, who was a Harvard Law graduate. Shortly after Kennedy got elected, our district attorney here, Bill Murdoch, was appointed the United States Attorney for Middle District. And the lawyer that I was sharing offices with, Mr. Edwards, became the district attorney, state district attorney. That, immediately meant that I could not handle any criminal cases or even traffic cases as long as I shared office with him. So that prompted me then in early 1962, February of 1962, to open my own office. At that time, my wife and I had 4 children. That's kind of a bold undertaking, opening an office with 4 children, 3 plus 1 coming. And so as a young lawyer, you take just any case that comes in the door and are thankful for it. The criminal practice in Durham was, you had old-time lawyers that had been doing it for years, and they just literally lived at the courthouse. So for a young lawyer who's got to maintain an office, you're at a big disadvantage. You just occasionally get a traffic case. This was before Gideon versus Wainwright, so there was very little court appointed. However, and I'm leading now up to the case involving my client here, Dr. Klopfer, and let me introduce him. Peter, if you will stand up. This is Peter Klopfer, Professor Emeritus in the Department of Zoology, and may I say, a firebrand Quaker.
Dr. Klopfer, in addition to being our sort of surprise special guest for today, and the man whose name is on the case, is also person who's along with his wife, co-founded the Carolina Friends School, founded the Lemur Center, which some of you may have been to. Has just done superb work inside and outside of Duke University. And since he's here, we can actually sort of hear directly, I guess, what happened. And this is leading back to what comes through, as Wade said. Lawyers take the cases that come through their door, and an interesting case comes through in the winter, I guess, of 1964. I guess it is. And Dr. Klopfer, maybe you can tell us just kind of what happened the night that led to this. And we'll have one microphone. I'll have to share.
What I should point out is that after the arrest of the five of us, all professors, either here at Carolina or at Central, Paul Hardin, who then was at Duke Law School, tried to find us an attorney. And he canvassed everyone in the region who was a member of the bar. And with one exception, was turned down. And Wade Penny was that exception.
And for what had you been arrested? To get the...
Well, I'll have to defer to Wade to what all the charges were.
What happened the night you were arrested?
But it was assault on a female, aggravated this and that and the other. We had been asked, this group of faculty, had been asked if we would approach the Watts Grill and Motel to see if they could be persuaded to integrate. The thought was that since most of the sit-ins were student-directed, student-conducted, that they were being treated as college student pranks. And the thought was that if a group of faculty approached in suit and tie and dignified fashion and attempted to reason with the proprietor, perhaps the ice could be broken. Watts Grill was chosen, we were told, because it was the favorite hangout after class for students and faculty. What we hadn't been told, and clearly we didn't do our homework, was that the proprietor was very active in the KKK, and that the reason the place was so popular among the Carolinians was because the motel rented rooms by the hour. This in a day when the dorms were still rigidly segregated, you understand. So in any case, we naively went there, but apparently word had leaked out, so we were waylaid in the parking lot, never really got inside. Were beaten and hosed and finally dragged off to jail with all these charges. And the next morning got ourselves bailed out and began the laborious task of finding someone to represent us, because the charges were pretty serious. It wasn't just simple trespass. And as I say, Paul Hardin had no success until he came to Wade.
This is where Wade re-enters the story. I should say, for those of you who know Watts as a restaurant, this is no relation whatsoever to Watts Grocery, which is the current restaurant on Broad Street, to which I know many of you have been. Watts Grill, I guess, is long gone. And I gather that you, Wade, had at least a sense of the proprietors here to kind of just flesh out what Watts Grill was like and what the Wattses were like.
Well, as Peter says, they had not done their homework. As most of you will find, that's typical of clients. Now, I'm speaking as a Southerner, but I'm very familiar with rural North Carolina. Both my parents came off farms. I've had relatives, small towns and way out-of-way places. If we were casting a movie today in which you wanted a person to play the role of a bartender in a biker saloon, Austin Watts would have been your choice. He's at least 6'2", and I'd say weighed probably close to 300 pounds, a massive person, and my impression probably never went beyond grade school. So this is, you can tell the dynamics, you can just about predict the dynamics, and I wasn't aware he'd been in the Ku Klux Klan, but I was not surprised at all either if he were. But, from his standpoint, he's trying to run a small business, and he'd already had a couple earlier evenings with sit-ins, so he was not in the mood for dialogue, so to speak. And so all of that then kind of showed up in the trial of the case, because that kind of rough-hewn personality is hard to conceal. So when he testified, I kind of thought that he might become on so strong and harsh that maybe that would work in our favor with the jury. But you know, when the court would give the charge, what the law is on trespass, simple trespass, and that's what we actually ended up trying. It was hard to make out a defense unless you just wanted to totally discredit what he had said. And of course, what we had in addition to his testimony was a deputy sheriff who was there and saw him, testified that the request was made and the defendant didn't leave. What I started to say, talking about law practice, and I mentioned this to Joseph the other day, the first case I ever tried in criminal superior court on a felony was, a lot of you are familiar, before Gideon versus Wainwright, you had to provide counsel for a capital offense, and the Supreme Court had also said under special circumstances. And I just mentioned this so that you can get an idea of what it's like, would have been like, to have what I call a country sole practitioner practice. Office been open about 4 weeks, and here came a call about 10 o'clock from the Superior Court. The judge wanted to see me. And I had no idea what that was about. I said, I wonder what in the world I've done that's wrong. What had happened was, and this shows you, I'm just going to give you Durham back in the 1960s. All the this was Superior Court, state court. All the regular criminal bar was over in federal district court handling moonshine cases. This is before drugs really hit this area. And the state court was sitting down there with nothing to do. And they had a prisoner who had been accused of sodomy at the state prison camp out here on Gesson Road, the victim being a 17-year-old who had no business being there to start with. And so they called me down there they needed to, Judge Hobgood, who was one of the best trial judges we ever had in North Carolina, recognized this was a special circumstance. This defendant had prior convictions, and he'd been in solitary confinement ever since he'd been charged. And so the judge told me that he was appointing me under this special circumstances requirement. And he's told me, go back there and talk to the defendant and then come out and let's get rid of the case. Well, the defendant said he was not guilty. And I came out and told the judge. And it was obvious the judge was a little kind of, wasn't expecting that. He thought it'd be a plea deal because he's already serving one sentence, it'd be a plea deal to help minimize sentence. So when I told him the defendant was pleading not guilty, he said, well, we'll wait then and start the trial at 2:30 this afternoon. This was about 11 o'clock in the morning. And I said, well, there are witnesses he says would speak in his behalf. So he said, give us the names and we'll go get them and bring them in. Well, there's some subjects, at least back then, we didn't cover in criminal law. And I was faced, this is happening, and as a young lawyer who's never tried a felony case in Superior Court, this is kind of overwhelming. At any rate, to make a story short, we tried it, and of course he couldn't take the stand, he was found guilty. And we went up on appeal, and the Supreme Court of North Carolina, in one of their more lucid moments, ruled in our favor that a per curiam decision didn't even bother that it was a matter of law that you can't appoint a person and give him just 3 hours to prepare for a felony case. At the time then, and I didn't tell Dr. Klopfer and my other Duke clients, but I never tried but just 2 or 3 misdemeanors. When they came a year later, a little over a year later, to handle their cases. And
And I should say these cases and the professors, other professors who were arrested, these would have all been white faculty because the faculties at UNC and Duke were both, I assume, entirely all white, as the student bodies would have been probably at that time. So these are white faculty and black students, I believe, from North Carolina Central, perhaps, who'd been arrested. So these are the cases that are showing up at your door. And as you said, there's pressure to take everything that comes through the door. Children at home, they're undefeated before the North Carolina Supreme Court at this point, batting 1,000%. But I imagine there must have been some, I could imagine some pressure not to take these cases, which apparently your other colleagues in the Durham bar had felt and given into. So why did you take this?
Well, the sit-ins had been going on for a while, and it's the old pouring new wine in old wineskins, and lawyers can get fixated in their particular view of society, just like everyone else can. And, you'd hear, at that time, the bar was small enough, and we were all right in downtown Durham, and we used to meet at lunch at the Palms restaurant. So there was a lot of, you knew everyone, and there was a lot of collegiality, something that's lawyers out there today tell me is really missing, because there are just so many lawyers and they're spread out. I really don't remember hearing, other than just side comments occasionally about irritation over the sit-ins. They had not really hit Durham that strongly yet, so it wasn't something right out on the street. My family had been in the retail furniture business here for years, and 85% of our customers were probably African American. We were full service furniture stores selling on credit. And I'm going to say now that I'd never seen, you had to treat everyone the same, because the only way you survive in that business is repeat customers. And so the idea that, when really forced to think about, that why, if a person's money is just as good to buy furniture or clothing or whatever else in other stores, why can't they go in a restaurant and the money be just as good there? So, and we all know there's an absurdity in how societies get off track like that. I really didn't feel that I was taking any risk. I thought the world of Paul Hardin taught evidence here, and he was young enough looking. He could have fit right in with all these students, and you'd have thought he was a student. But he'd been with a large law firm in Birmingham, Alabama for 3 or 4 years and came back here to teach evidence. About the same time this got started, we formed a small group to meet at Duke. Had 2 Duke professors, Gene Grueling and Jack Price, who were sociology department, and Paul Hardin, George Miller, who's a practicing attorney here, who later served about 10 terms in the legislature. When I left, he ran for my seat. And Ellis Jones, Sr., who was with the Durham Committee on the Affairs of Black People, which was the organized political group representing African Americans in Durham at the time, a big factor in elections. He was chairman of the political committee. And that committee was meeting out here in the law school. We'd meet about twice a month just to have an open dialogue as to what we were hearing in the community. Now, this is probably 63 and 64, 65, trying to move as quickly as we could to the adjustments we thought were going to have to be made, and just out of the public's eye, just quietly to open up channels of communication, which were important to the representative of the Durham Committee to get an idea of how, as these developments are occurring, what are we hearing and what are the opportunities to make progress by contacting the right people or taking the right approach.
Now, in terms of those developments, by the time that Dr. Klopfer and the other professors get arrested, there have also been some students who've been arrested and are facing charges. I wonder if you could just give us a sense of how the legal system's processing those cases and where this is all happening. Give us a sense of the legal scene there.
Well, Chapel Hill was the focal point because this was mainly students at UNC and in Chapel Hill High School. And obviously, again, the reason is that the feeling was that the town of Chapel Hill so depended on the university as a matter of its main economic source of funding for businesses that that was a logical place to start to achieve voluntary desegregation in North Carolina. So the students had been active, and the numbers were growing, and the intensity of it was growing. So the state, I guess, they were only having moderate success at that point. Some establishments had opened, but a number of them had not. And so apparently in response to concerns of the businesses that were not going along, the state, I can only surmise that the solicitor probably requested a more formidable judicial presence than what we'd had. Although, well, let me say this. The first case we tried of my clients was tried in February, about 6 weeks after the arrest. And so that was David Smith, the math instructor here. And that Superior Court judge was a resident judge for Durham County, trying cases. Our Superior Court judges circled through about 8 or 10 counties. So he was in Orange, and I knew Judge Hall, and David was tried, took the jury, I think, about 10 minutes to come back with a verdict. And they tried each professor separately, even though this was a simple fact, basic fact case. In ordinary, they might have tried people together. They tried everybody separate, and the idea was the publicity and to make an example of them. So what David Smith was the first case I tried, and then he got sentenced, I think, to 60 days active sentence, hard labor. And then, of course, that case took about 2 days, I think, by jury selection, and they only had about 2 or 3 sessions of criminal court in Orange County every year, 1 week. So obviously, with all these sitting cases, they were going to have to increase the number of court sessions. So they brought in Judge Raymond Mallard, who, among lawyers, was generally considered to be what we call a hanging judge, very strict and relatively punitive if he thought you were really deserved it, or even if you didn't deserve it, as we thought. And had him hold a special 3-week session of criminal court. And again, with what they did was they required all the students who had been charged with trespass had to be in court every day court was in session. He would not let them read in court. So you just sat there watching the professors be tried one at a time. And so I had a couple more trials. I think Peter was probably the 3rd or 4th that we tried. You probably wonder, well, what do you say as a lawyer if the facts and the law are so much against you within the context of state trespass law? Well, the only thing you could argue was American history. You argue against the credibility of the state's witness, and then you argue and try to awaken some sensitivities about what America is really all about. And if you ever go up to Orange County outside the old courthouse, you've seen these big historical markers that commemorate significant things. The one marker up beside the old courthouse up there is a tribute to the regulators. These were small farmers up here in Piedmont, North Carolina, who, before the Revolution, the colonial government was taxing them pretty heavily, and they didn't feel like they were getting fair representation. So they protested and actually bore arms and got up an informal militia. There was a skirmish. Some of them were arrested, and 2 or 3 were hanged for insurrection. So that was my example of, we have a history and tradition of civil disobedience, and people paid a price right here in the very county where we're now trying these persons who are basically striving for the same thing, basic fairness. But it makes a good jury speech. It didn't have just so much effect. What helped us was, in Dr. Klopfer's case, one of the jurors called was the daughter-in-law of an elderly Episcopal minister in Chapel Hill who had been real active with the students, and I think had been arrested for trespass himself. The state somehow missed asking her, was any relative or friend active in the, she was from Chapel Hill, whether or not she had anyone, close to her who had been active in the trespass cases. The state just failed to ask her. So she got seated on the jury, actually was the foreman of the jury. And to make a long story short, she and the initial vote, I think was 7-5 in favor of acquittal. Now that's partially because Peter did such a good job testifying that he awakens a sense of conscience. Also, a thing that helped us was about half the jury of 12, 6 of them were from Chapel Hill and roughly 6 from rural Orange. So naturally, you didn't stand much chance with the rural factor, but to have 6, shall we say, urban jurors from Chapel Hill. But as the jury deliberations went on, it gradually shifted to where it was 10 for conviction and 2 for acquittal, and she held out, and therefore the court had to declare a mistrial because they couldn't agree. And while we're talking about getting to the Supreme Court of the United States, it's just interesting how little factors you don't even realize what impact they're going to have change the course of a case. Had we not gotten a mistrial, we wouldn't be sitting here today. At least Peter and I wouldn't be sitting here. The fact that she held out, we were getting close to the end of that 3-week special session. The regular criminal docket in Orange County was building up because they weren't processing any of their regular criminal cases, just trespass cases. And so finally the pressure of handling the court's other criminal procedure obligations forced the district attorney to delay then retrying Peter. And what happened after that was that he kept putting us off, and again, because there was just so much other work to be done, and then the Supreme Court, well, first of all, Congress passed 1964 Public Accommodations Law, and then in December of 64, Supreme Court confirmed the constitutionality of that law, and then shortly thereafter made it retroactive, and the law actually forbade prosecuting anyone who had sought public accommodation. So when they made it retroactive, that meant we contended that his prosecution was abated by it. So that's...
So one would think, as a background of federal law now, just for those of you guys who would know the Civil Rights Act, in the interim, since this event has happened in January 1964, Congress passed the law and the Supreme Court's upheld the provisions that would protect people like Dr. Klopfer, who'd been engaged in sit-ins and protests in order to effectuate the purposes behind the Civil Rights Act, so that there's a good legal defense under federal statutory law, but there's a problem with presenting that defense, which is...
Well, we went through a couple of continuances where the state requested continuance, and so then I approached the solicitor about bringing the case on for a hearing so we could plead the benefit of the federal civil rights law and the court decisions. And we got, finally, in a hearing before the court, the solicitor indicated to me right before the court started, this was April of 65, over a year later, that he was going to take what's called a null pros with leave. And in North Carolina, that meant that you were free to leave the court, didn't have to post bond or so forth, but that the solicitor, at any time in the future, without even having to ask the court, could issue a warrant or have the clerk of court issue a warrant for you and bring your case back in before the court. And with an all prospect leave tolls the statute of limitations. So theoretically, you could wait 10 years, 15 years, 20 years, and bring the defendant back in. Well, that has, I think all of you can recognize, that has all kinds of, for innocent defendants, all kinds of negative implications that you've got a potential charge hanging over your head, and it's on your record, but you have not been given your day in court. Now, a lot of defendants are tickled to death to get it, because what it is an informal version of parole or probation. A lot of times the court, and sometimes it was used well, for instance, a young person who'd gotten in trouble, but you thought, well, this is going to be a one-time occasion. We're not putting him on probation. I'm just going to let his lawyer know that we're going to let you go this time. But if this comes up again, I'm going to bring this charge up plus whatever the new one is. So a lot of times lawyers tickle to death to get it for their clients. On the other hand, if you're challenging the status quo, as Peter was, or all these students were, then it can be an intimidating thing that I'll let you out, but if you ever violate the law again, we're going to bring you back on both charges.
And for someone like Peter, at the time, I assume applying for grants and trying to travel for work, you've got this charge hanging out, you've got to reveal, must be a serious sort of, the sword of Damocles is hanging there. So how do you start moving?
The judge ruled against me. We raised the right to a speedy trial then. The judge ruled against me. And the solicitor then changed his mind and kept it on the docket. Well, then we got to August, and then made a formal motion. I mean, I recognized that we weren't going to get cooperation. And part of it, and I think Peter would agree with, part of it was a personality conflict between this rambunctious Quaker and a much more traditional, trained district attorney. And I think the district attorney kind of lost his objectivity about it. So in August, we filed a formal motion, as all of you good constitutional law students know, and you've got to be careful to lay the foundation if you're going to raise a constitutional law issue. You can't wait till you're up on appeal to do it. You've got to do it in the trial court ordinarily. So we filed a formal motion that really set up the argument based on right to a speedy trial. And that was denied. And we went up to North Carolina Supreme Court, and we got a 7-0 ruling against us. And let me say at this point, all these individual trials and individual trial records and appeals, so forth, takes a lot of work by someone other than the lawyer. And even though I had a regular legal secretary who was good, a lot of this was very precise. And I will tell you, the other reason, if it weren't for my wife working with 4 children, coming downtown at night and helping me prepare all these legal documents, I wouldn't be sitting here either. So I wanted to give her, she's sitting right here on the front row.
You're here.
Watch it.
It wasn't quite as easy as on the computer. And the result, or one of the results of that, actually is the brief, which
Yes.
fortunately brought a copy of. This is the Supreme Court brief, so this is coming after the certiorari petitions. Of course,
And
you got to get
I'm
the
going to
court's
leave this
attention.
with Joseph, if any of you are just curious to see what one looks
Very
like.
cool. Well, how do you think you had to, and of course you got to, before you can get to court, you got to get their attention and get cert granted. How did you shape this case so that the Warren Court would take it, or how'd you think that through?
Well, first of all, let me just mention briefly the Supreme Court of North Carolina case said, and this is just a reflection on sometimes how bizarre courts can be. They said that we understand the defendant has a right to a speedy trial if there is to be a trial. Which, if you got, the inference being, well, if we deny him a trial, we don't have to give him a speedy trial. If we just deny it completely, and that's basically I might have helped us get to the Supreme Court of the United States. I mean, that one state. Well, I was aware of the fact that the Supreme Court had started the incorporation process of bringing specific rights from the Bill of Rights into the 14th Amendment due process clause. And my feeling always was that I could have, in contrast to what the Supreme Court of North Carolina did, I could have walked out on the sidewalks of the city of Durham, asked the first 10 laymen that I saw, would you agree, or do you think it's possible that the state of North Carolina can charge a person with a criminal offense and never give him his day in court? And I'm satisfied 9 out of 10 would say, of course not. And yet our Supreme Court had ruled 7-0. So it was a question, you try to draw attention to the obvious and to spell out as many possibilities in the petition for writ of certiorari as to how this procedure undercuts right to a speedy trial and what the consequences are for the defendant. And of course it was the Warren Court, so it was, if you were ever going to bring a question like this to the court, that was probably the ideal time, certainly within recent memory, of the court being conducive to hearing that. A graduate student at Carolina did his master's thesis on this case, and then it won a prize, and it was published, and his paper was published in the Journal of Supreme Court History. He went to Washington, D.C. and did some research, things that I did not know at the time. The vote was 6-3 to grant the writ of certiorari, so that we went into the hearing knowing, I didn't know it at the time, I just knew they'd granted it, but that showed that the court was really interested in, as it got the opportunity, and it recognized the opportunity in this case to deal with right to a speedy trial. It already had, I think, incorporated right to a public trial and the right to confront witnesses out of the Sixth Amendment. And the only debate, maybe on the court at the time, was whether you just declared this was inherent in the phrase due process or whether you did the incorporation from the Sixth Amendment. So
this is, by the way, for any of you who are first-year students and haven't gotten to this part in common law, you just learned incorporation doctrine in about 5 minutes there. So you're ahead of the game. So you do get the grant of certiorari, which is the first hurdle to get over. So at this point, you're going to be making the arguments. You're 30 years old maybe at this time?
30.
Probably younger than some of you in this room. How do you start preparing for a Supreme Court argument on a case like this?
The year I had the fellowship in Washington was the year, as I say, that Kennedy ran against Nixon. And so the congressman, all of the congressmen that fall, and we went up in August right after taking the bar exam, all of the congressmen were back in their home districts running for office, so there was very little workload going on in the congressional offices. I would love to have been able to participate in the, in the election with one of the national campaigns, but our director of the foundation, Albert Coates, who was head of the Institute of Government at Chapel Hill, was rightfully concerned that he didn't want a nonprofit foundation to appear to be supplying campaign workers in a contested election. So he said we couldn't, even if we were going to do it on our own time. So I had a lot of time to go, free time. I'd go to the Supreme Court and watch oral argument. And I can tell you right now, that was a big help, because the only time I guess I've ever really felt intimidated was that hour. You're sitting there in the court before it's your turn to present argument. You just know it's such a special place, and just the atmosphere. I'll use overworked term of awesome. It's an awesome thing. And but I had the advantage of watching oral argument in a number of different cases through the fall of 1960. And then when I did file the writ of certiorari, I took it up there in person to make sure that, at least on first reading, the clerk's Supreme Court didn't find any technical fault. And let me say this, if you're the Bible for knowing how to go to the United States Supreme Court was a volume by Eugene Gressman. Is that still a current?
It's still available. It's still my reference.
Yeah.
Just
I
local.
doubt if the procedures changed much.
That's probably right. Yeah. Gressman also.
I'm sure there's a more recent edition than the one that I used. But it was so important, I still have it, because it wasn't a very reliable and well-written guide to exactly what you had to do in terms of the paper and the format and everything has to be exactly right.
It would have been hard to prepare, too, for the kind of oral argument that you ended up having. It's to read the transcript of it's pretty extraordinary. And I should say, as a footnote, the article that Wade mentioned, I have copies of. If anybody's interested, I can provide you electronically. It's just an amazing, amazing story. But maybe you could tell us kind of what the day was like when you and the state's attorney show up to argue this case.
Well, really, I don't remember much of that. I'd gone up, my wife and I had gone up, we were the night before, and so I was there early, and I think there was one case ahead of us, if maybe Peter remembers. So you're sitting there, you're waiting through one case, and so we were allotted 30 minutes each side, which is the typical. Some major cases say an hour, I guess, and I guess occasionally maybe even more, but typically each side's allowed 30 minutes. I took the position in the brief that the court didn't need to have an extended history of the origins of the right to speedy trial. I relied heavily on Magna Carta and English constitutional law history, and then obvious that it was carried over into very much in the concepts of American jurisprudence as British law was being used more and more in the colonies and then at the time of the founding of the country. And but there were also some recent Supreme Court cases in which they defined the importance of a right to a speedy trial, even though they had not applied it to the states. These were federal defendants who were raising the question. But it was mainly just to present straightforward in the brief, and as I say, I left Joseph a copy of it if you want, just to kind of see how one looks. I just felt like it was such an obvious proposition that it was so fundamental to due process that you just didn't have to, I didn't go through and like a real good legal academic would do and give you what every state's constitution provided. It was clear that virtually every one of them provided, and North Carolina did also for right to a speedy trial. On the questioning, mine was very straightforward. They just wanted a clarification on exactly what null pros null pros is where you take the case off the calendar, and if you want to reinstate it, you have to have permission of the court. The district attorney would have to ask the court for permission. Null pros with leave is where it comes off the calendar, and the court, in a sense, gives us advance consent. So the solicitor district attorney doesn't have to ask the judge for permission. Well, the Supreme Court wanted to make sure it completely understood what North Carolina procedure was and that we had no other alternative to get a trial. And we dealt very little with the law. And but then when the state's attorney stood up, Andy Benori, 28 years old, boy, they really lit into him. And he had, I'm convinced the state's attorney general just sacrificed Andy that day. If you read the article, the person writing the article was able to obtain, and I have a copy at home, an audio tape of the oral presentation of this case before the Supreme Court of the United States. And if you listen to it, one thing that will strike you is that just wonder how many civil rights cases had two slow-speaking Southern drawl attorneys arguing before the Supreme Court of the United States. But they really went after him and basically forced him. He couldn't defend it. He tried, but he basically ended up confessing error for all practical purposes. And I always thought the Attorney Generals kind of, they knew what I'm sure Andy knew what he was getting into, that they knew what he was getting into, and just, again, that resistance to admitting error, the resistance to admitting that there's a change, can be very generational, can be very regional, and they should have given him the authority to admit. Because there was no great admission to say, yes, we now on reflection say that this is a denial of right to speedy trial.
So when the arguments end, you've got, I assume, feeling pretty confident based on the result, which we've been sort of holding back the conclusion here. Why don't could you tell us where you were when you found out, or how you found out about the result, what you were doing at that point?
Well, in the same year that I was preparing that case, the papers and the briefs and everything, I also had decided to run for the legislature, representing Durham County in the House of Representatives. And so the case was argued on December the 8th, 1966, and I'd been elected that November. Durham County at that time sent 3 representatives to the House. And then the legislature convened in mid-January of 67, so we were about 2 months into the legislative session when the decision came down. It was reported in and out, people just took it, didn't make any big deal out of it. I kind of expected there, again, we were still, the civil rights situation in this area was still tense enough that when I was serving the legislature that first session, we were having curfews in Durham. And the reason I didn't get stopped coming through Durham at 10, 11 o'clock at night from Raleigh while we were in session was that if you serve in the legislature, your license plate, for instance, mine gave your house seat and your number, so the officers knew who it was. And I didn't get stopped, but anyone else. But, I didn't know what reaction I'd get when, you'd sit there, because North Carolina was still predominantly influenced by Eastern North Carolina Democrats, and very much a Democrat legislature, both urban and rural, except for far western North Carolina, very different from what it is today. But let me say this, during the time that I represented the defendants, and in spite of the fact that these law firms and lawyers didn't want to take the case, no one ever made a critical comment. I mean, when I go into Palms to eat lunch, they may have been critical, but they just never said it. So I hope it was reflected that at least we had enough professionalism among the lawyers that no matter what their personal opinion, and neither did any layman. The only time I ever got a public reprimand was that in running for the legislature in 1966, there was an independent running, Joseph High with the White Citizens Council, which was kind of the less violent political wing of Ku Klux Klan. They're really not related, but you had a lot of crossover people. And he was running for the legislature and I guess I'd been over in Orange County searching a title or something. I was coming back to Durham, and he ran one of the few political ads he could on the radio, and his complaint about me was that I stood up to the solicitor. Well, that's what defense lawyers do. So I don't think I lost any votes then.
Probably not. So we've come to the conclusion of the story of the case anyway, that we've got the result, and I promised that we'd save a couple minutes. We got about 4, I think, for any questions that y'all might have for an undefeated Supreme Court advocate here who argued this landmark civil rights and criminal procedure case. And Wade said he'd be happy to take a question.
Let me say one other thing. I love serving in the legislature. You never know where you're going to find yourself, with the legal training. How are you going to really use it? I'll confess now, I really didn't like law practice. I don't like the deadline. I'm very much independent. But I love the legislature because unlike handling, it's an important function to represent criminal defendants. It's the only way our system's going to work. But there are other lawyers willing to do that, and as long as other lawyers are willing to do it, I decided I'd much rather make a bigger difference if I could in setting the course and direction of the public policy of the state of North Carolina.
Now.
Well, I wish I were too. We had, at that point in time, we didn't have near the polarization that you see today. Now, the only polarization, Eastern North Carolina, as a conservative bloc, had an unyielding influence on legislature, but it wasn't always negative. And the young lawyers we had there, both Republican and Democrat, reflected the training we'd received in the law schools of North Carolina, in the sense that when we had major bills, and judiciary committees is where the lawyers do the most good, because not only do we consider bills introduced that are referred to judiciary committees, a lot of times bills that have gone to another committee that need more work on them are sent to judiciary committees. So you, in a sense, you become kind of a lawyer for the legislature in addition to your regular duties. And I just found that work to be far more interesting. You feel like you've made a difference. I just am disappointed that the progressive tradition of the state of North Carolina has been interrupted for the last 4 years. I just hope the pendulum is going to swing back the other directions to where we are a lot more objective and thorough about our decisions on public policy.
It's a wonderful place to conclude because this is a chance there's an invitation, I think, for all of you to be part of that pendulum and to make a difference in the way that Wade Penny's described. So let me, on behalf of all of us, offer just a little thank you and in physical form and an immense thank you from all of us for coming.
Well, thank you.
All the work.
It was my pleasure. Thank you.